My name is Jenna DiFrancesco, and I am the chair of the Real Estate Practice Group at Burns White. Welcome to the very first episode of Real Estate Real Talk, a video series where I take a legal look at your everyday property issues. Today, we are going to be chatting about real estate tax assessment appeals. Many of you are watching this video may be looking for help deciphering an appeal letter and form you recently received in the mail, notifying you that the school district or municipality is appealing your property value. If you recently received these documents, you might be wondering what steps you should be taking to handle the appeal. Step 1, look at the reason that your property value is being appealed. If you are getting an appeal notice, it is most likely you recently purchased your property or made an improvement to the property. Knowing the reason your property assessment is being appealed will help you prepare for the evidence that the taxing body will present at the hearing. This will enable you to bring the best evidence to the hearing to refute the valuation number that the taxing authority will be trying to prove. Step 2, determine if your property is being overassessed or incorrectly assessed in the tax records for the county and look at comparable properties in your neighborhood. Check the official tax record for your home for mistakes, including the size of your home and lot, improvements, number of rooms, or purchase price. If you are getting appealed because you recently purchased your home, it will be important to look at the assessed values of comparable properties in your neighborhood. If you recently added an improvement or an addition to your home, it will be important to look at comparable properties in your neighborhood that have a similar improvement to one that was recently installed. Comparable properties will be those that are similar in size, amenities, rooms, and age that will help estimate the value of your property. Step 3, be ready to prove what the taxable value of your home should be, including providing evidence of an inflated seller's market, comparable home values, defects in the home, or inaccuracies in the tax records. You will need to be armed with evidence why the purchase price is higher than current fair market value for comparable homes in your neighborhood. It is important to note that the taxing authority cannot simply show up at the BPAR hearing with just the deed for your property and present the purchase price for your property as evidence. The taxing authority needs to provide evidence of comparable properties. If the taxing authority attempts to show up with just the deed, you should move to have the appeal dismissed. Because hearings have been moved online, you will receive the taxing body's evidence 5 days in advance of the hearing. Go over this evidence in depth and be prepared to make arguments regarding why comparable properties introduced by the taxing authority differ from your own. Hire legal counsel for representation at the hearing in front of the Board of Property Assessment, Appeals, and Review. This will be your first level hearing. Step 4, once you receive the BPAR's decision, you will need to decide if an appeal should be made to the Board of Viewers. It typically takes anywhere from approximately 60 to 90 days for a decision to be rendered by the Board of Property Assessments Appeals. This decision is called a notice of disposition. Both parties have 30 days from mailing of the notice of disposition to file a de novo appeal to the Board of Viewers. This means that the evidence submitted by both parties to the Board of Viewers can be fresh or new and can differ from that evidence which was presented at the initial BPAR hearing. If you aren't successful at the first level hearing, the good news is that you're able to start fresh with the Board of Viewers. If you have any questions or concerns or need assistance with your own property tax assessment appeal, feel free to reach out to me directly. I would love to help you.